Mr. Speaker Pro Tem and members, Representative Charles Owen moves to call from the calendar his House Bill 450 on the notice given list.
Without objection. Representative
House
Owen.
Bill 450 by Representative Charles Owen, Children's Code relative to an adopted person's original birth certificate. This provides for disclosure of confidential records.
Representative Owen on your bill.
Thank you, Mr. Pro Tem. Members, thank you for those of you who were here on Thursday who listened. Thank you for those who went back and watched the tape live. I know most of you are listening right now. In a lot of ways, I feel bad about putting us all on the spot like this. But we have been put here because we volunteered to be here. As I tell people all the time, I was not drafted. This bill is about birth certificates for grown people. These are grown people who are party to a contract that they did not consent to. As I told you Thursday, I am the object of the contract and I did not consent. People want these documents for a lot of reasons, and I won't drill down into them. But what I will tell you is that this bill is about a grown person having access to a document that they are named in and that they can have by government edict. To refresh, I know not everybody heard this Friday, when a baby is born in Louisiana, wherever that baby is born, a birth certificate is issued. The place of birth, the name of the child, the parent or parents. When that child is surrendered to someone, an agency, in my case, an orphanage type of facility, that birth certificate goes with that child. And that mother surrenders that child their surrender documents. There's people sitting right back here on this back row who signed a bunch of those. They signed those documents and they surrendered their control over the actions and the life of that child in perpetuity. And I applaud a birth mother more than anyone will ever understand, because my birth mother gave me a wonderful life. My birth mother was the child of a Methodist minister who was already married and divorced once. So she was a pariah in 1962 already in rural Mississippi. And then she got pregnant out of wedlock and had to disappear. I applaud her life because she gave me life, and that has always been my central focus to this. But then the child is given a new birth certificate when they are adopted, which I was. My birth certificate says my name is Charles Anthony Owen, and my parents are Creighton and Gloria Owen. And I was born in New Orleans, and there's an annotation on there that says I was adopted. And this is the case for everyone. Some people have gone back and forth as to whether or not I need to lay my story out. It's not my story. I'm speaking for people who have this story. But this child is given a new birth certificate, and years later, if they decide to ask for it, if they decide they want to know where they were born, what their name is. My birth name was McBride. I thought I was Welsh my whole life. I guess I'm Scots-Irish. A grown person ought to be able to get their birth certificate, and that's what this is about. There's a lot of layers to this. I've spoken to nearly every one of you. I've looked every one of you in the eyes, and I know people have questions. And what I'm going to ask as we go forward is ask me the questions and keep thinking. A whole bunch of you have said, Chuck, I don't know. I'm just going to listen. I don't know what I'm going to do until I reach the button, and that's fine. That's why we're here. So, Mr. Pro Tem, I'd like to offer up questions, or I understand there's an amendment to the bill that we need to do first. Mr. Speaker?
All right, we do have a question.
Yes, sir.
Take up the amendments first?
I'd rather ask your questions first.
Okay, let's take up the question. Representative Stagney for a question.
Thank you, Mr. Speaker. Representative Owen, there are other states that are open like this where you can go get a birth certificate. Has that led to an increase in abortion? Because there's an assertion out there that it may.
No, sir, not at all. The inverse is true. In every state that I have data on, Alabama especially, they're the test case, not a test case, but they're what I've zeroed in on. They're like us. They're a rural southern state, and their rate of abortion decline is faster than ours over the period of time that they've had this law in place. And they've had this law for 22 years.
And there's data behind that, correct?
Sir?
There's data behind that.
Yes, sir. Absolutely. I'm staring at it.
Okay. Thank you, Representative Owen, for bringing the bill.
Thank you.
Representative Mincy for a question.
Rep. Owens, I I want to just thank you again for bringing this. I mean, it's obvious the passion that you have for it, and deservingly so. You know, you mentioned that this bill is all about, you know, whether an adult deserves, their birth certificate. But there's also been a question about, you know, the commitment from, you know, or the understanding of the birth mother whenever they gave the baby up for adoption. And I'm still struggling with trying to understand that, and we've talked about it, and I thank you for answering questions and asking people. I thank you for bringing this back to the floor after you last week to give us some more time to think about it. But the one piece that I haven't figured out yet is, you know, that you hear that there's no contract, there's nothing, there's no obligation, there's nothing there, but yet it takes a judge to currently to allow that exception to go into effect. Can you explain it? Can you help me understand that? Because I'm still struggling with that.
Yes, sir, Representative Mincy. There's a couple of points there. The birth mother surrenders the child, and she surrenders all rights to that child, including what happens to his or her papers and belongings or anything else. So put that on the side burner. The law as it stands today, if someone like you or me or anyone in this room who is an adoptive person is looking at a grown-up looking for their birth certificate, they have to go to a judge, and a judge has to determine if they meet this compelling reasons test that was established in 1977. Compelling reasons, to my understanding, are health-related or verifying someone in the registry that Louisiana's created or inheritance. Just wanting to know who you were, where you came from, the fact that it's your document is not apparently a compelling reason. So this lays in the lap of a judge that we have empowered. And as I told y'all last Thursday, prior to 1977, which includes my birth, the only requirement was going down and asking for a court order, which had no test. So everyone born from 77 before was grandfathered out of this. So that's where we are. And what I want to do is make a grown citizen like me, like the 70-year-old guy from Eunice, like all kind of people I've heard from, walk in and say, I would like my birth certificate. I would like to know where I'm from. It's their document.
Yeah, and I commend you for that effort.
Yes, sir.
I'm just trying to have a better understanding of that original, you know, what the original was. Because, I mean, it just seems to me, if it's not required now, which is what you hear the narrative is, it's not required, then I just don't understand why the judge has to make that decision, and the fact that someone just wants to know themselves is not compelling enough. So I'm just trying to understand that original component.
Thank you. I don't know why they did that either. I have some inclination, and I told y'all about that the other day, that the original intent when drafted, as the clerk told me, was to protect adoptive parents from birth mothers coming back trying to get their children. Now, as far as an agreement goes, this comes up a lot. It just came across in a floor note a minute ago from one of my dear friends. If confidentiality and an agreement in perpetuity was promised, it may have been done with good intentions and people trying to facilitate adoption and trying to talk somebody into making a hard decision. But there's no real force in law in it. It has become a bad myth. You know, buddy, Representative Mincy, I write books people don't read. I've written several football books, and I often go and I did this because back home we have all these myths about what guys did when they played football over time. And sometimes I get tired of myths and I want to either codify them or rectify them. And this myth that has been brought up is now, it's the paradigm of the state. And what the law still will do going forward is that 24 years, it's 24 years before that person can have their birth certificate. That's a good long time.
Thank you, Repo.
Yes, sir.
Representative Amity for a question.
Thank you, Mr. Speaker. Rep. Owen, I have about 3 questions for you. Your bill came before civil law, and we discussed it on 2 different days because of some of the witnesses who wanted to testify who were from far away and couldn't come back the second time. So I think we covered a lot of territory there. And so for the sake of the body, I'd like to ask you a few questions from some things we had discussed in committee.
Yes, ma'am.
You were just speaking about confidentiality and anonymity. In our discussions in committee, did we conclude that there is any realistic expectation in this day and time to either confidentiality or anonymity?
Well, we concluded, and Representative Nelson brought this up most poignantly, is that in law there should be no expectation of it because the law does provide for a way to get it. And in truth, the world we're living in right now, in the world we're living in with DNA, the days of anonymity are gone. If one person surrenders DNA and another person surrenders it, those things can be traced. So there's limited expectation of that, and there's none in the law that I know.
And so with this kind of DNA testing, it doesn't even necessarily have to be the adoptive person who's now an adult and the birth parent. It could be siblings or immediate relatives who could end up getting a DNA test that might connect dots. Is that so?
Absolutely. On the DNA side, I mean, that's often how it happens. Representative Seabaugh talked about that in committee about, people start connecting dots and they start drawing lines and they find those things out. So what this bill does is this makes it a conversation between two adults, someone who's at least 24, usually older, I would guess, and a birth parent, and a conversation that if a person wants to initiate, they can, and handle it that way, as opposed to it being out there in the public domain with DNA.
And you mentioned a moment ago about current law requires that an adoptee would go before a judge with compelling reasons, and health is sometimes deemed a compelling reason, and inheritance might be a compelling reason, but your bill starts at the age of 24. Can you explain why 24?
Yes, ma'am, it does, because I was advised by staff committee, Chairman Miller's great staff, that because of our forced inheritance laws in Louisiana, if you appear in someone's life like that, after 24, they can make a decision in their own will whether or not you're going to be part of their will, their estate. If it's before 24, then forced inheritance goes into effect. So I was trying to remove that from the conversation.
So if your bill passes, then it prevents someone who knows that they were adopted from finding their birth parents and going after an inheritance against the birth parents' will because forced heirship is over by the age of 24, correct?
Yes, ma'am, that's my appreciation.
Okay. In 1977, when our current law was passed, was it to protect the birth mother or the adoptive parents?
Well, as I was told by the clerk who called me the other night, a gentleman's 86 years old, he called me on the phone and he said, I see what you're doing, and let me tell you about it. And I was on the phone with him probably 90 minutes. He said he was a clerk at the time and a senator from the Baton Rouge area who had adopted children, encouraged him to write this bill to put up a wall of protection for the adoptive parents. The birth mothers were not in the matrix at that time of the original intent. Now it has grown into that discussion and perception.
Right. And what were the adoptive parents being protected from, according to those people who presented the original bill in 1977?
Well, going back on the consent agreement that they signed to turn their children over and basically let these other people rear their child for disruption in the life. And so I think at the time it was 18. You could go to 18. Now with 24, that's a pretty long wall of separation.
And one last question. When you presented this bill each time in committee and then last week on the floor, you mentioned that the bill really isn't so much about finding people as much as it is about having access to a document that the government holds but has your name on it. Can you talk about that for a moment?
Yes, ma'am. I am a privacy person. I am a right to privacy person, and I am a transparency person. I don't want the government making you, Representative Amade, or any one of our colleagues in here permanent wards of the state. They basically make adopted people permanent children, and they get to know something about you that you can't know. And so that irritates me. I want government to work, but I am innately distrustful of government, all levels.
Do you think the government, I said I was going to do 3 questions, here's the 4th one. Do you think the government already knows more about us than we know that the government knows about us?
I'm utterly confident, yes, ma'am.
Thank you, sir. Thank you for answering the questions.
Yes, ma'am.
That's all, Mr. Speaker.
Thank you, ma'am. Representative Fontenot for a question.
Thank you, Mr. Speaker. Representative Owens, first, I appreciate you bringing this bill and having the dialogue. On Friday, I had to spend a very historical moment with my son, but I took a moment to watch you. And there's a couple of things that you said I thought really struck me. One was about scores of mothers agree to this. Is that, can you elaborate on that?
I've had scores of mothers who have reached out to me directly, who have told me to keep doing this. Now that's direct communication. Some of them are here today. Mothers who surrendered their children, who signed release documents and have told me this is the thing to do, keep going, keep going, keep going. I've heard from a number of organizations. The last floor note we got, right before we got the one from Family Forum, listed all these organizations. A lot of them are mothers' organizations who are pursuing, who are encouraging laws like these around our country for transparency.
So I'm assuming that there are adoptive children each day through ancestry, through DNA, that find their mothers, correct?
Every day.
And do you know
I'm
of
sure.
any negative instance where it's been negative on the family when they've been found?
Do I know of any?
Yeah, do you know of
Yes,
any?
I do. We all do. If you really got into your own phone book and started talking to people, these things happen. In fact, I'll tell you this. You asked. Last Friday, I decided I was looking for a reason to make everybody more informed in all this. And I got a hold to Gene Mills' counterpart, the Family Forum's counterpart in Alabama. I asked Gene, who is your counterpart there? I want to find out what's happened there. Long story short, hardly anybody in the organization remembers anything about it. It's 22 years ago. I couldn't find anyone that had told me the sky had fallen, but I did talk to one guy who was there. And he's a pastor and a psychologist. He had 2 adopted kids of his own, adopted in Texas. Very close situation. Both of them used DNA. One had a good situation, one had a bad situation. And all of that is, okay, I get that, and that's superfluous to the point to me that grown people are going to do what they're going to do, and then we need equal rights.
Would you agree, Representative Owens, that if we gave the mother the option, if she wanted to meet the child she gave away, it would prevent those negative times?
I think the mother already gave the child away. She already signed the consent form. She already said, I have no control over your document going forward. I think that moment has passed. I think and hope that a grown-up would handle this well, that a 24-year-old woman or a 58-year-old man would handle it well, as opposed to just knocking on, but I don't know.
But a simple addition to your bill that would say the mother must consent if the child is looking for him, would you not agree it would prevent any negative moments?
I don't know that it would prevent any negative moments because DNA is still there. And if someone is persistent enough, they're going to find them anyway.
So
I'm sorry.
If that's factual, then tell us why we need this bill.
Because this is about a piece of paper with Brian Fontenot's name on it that the government has that you can't see, that someone else relinquished rights to 53 years ago. I know you're 40 years ago. However long ago that someone relinquished this right. And as I said, we respect that decision, but that's your document that the government holds.
And I agree with you, but we still have an obligation as lawmakers to protect the people that are involved.
We do.
How many states in the United States right now do not allow this?
Do not allow?
Yeah.
Well, there's 10 that do. There are and there are 40 that have various matrices of what can and can't be done. There are 10 that have clean bills.
That are restrictive. That is correct.
Yep.
Representative Owens, you said a statement. You said, I know that this bill will have collateral effects. What makes your decision to move those collateral effects to the mother and away from the adoptive child?
They've been having collateral effects since this bill was enacted. They always have collateral effects. I don't know that they'll have bad collateral effects, but I know they'll have collateral effects that are in the positive of the people who are trying to find their story.
But do you believe that those collateral effects or negative effects are going to be greater now on the mother than it was prior to?
I don't know that. I don't know that and I'll tell you why. I've not heard from any, and I know some of our friends on my side of the aisle say you haven't heard because they don't want to talk to. But I just don't know that. I don't.
Is there anything in your bill that protects the mother that gave their child up for adoption?
Protects them?
Yeah, protects them from a hardship that they may encounter. Does it protect the victim of rape if they choose not to be located by their adoptive child?
Well, I think we're going down a rabbit trail, respectfully speaking, of what ifs. And that there are a million what ifs that we could talk about there. There's an amendment coming up to discuss this very point. And there's a million what ifs that we could go down that rabbit trail. I can tell you about a what if phone call that I had today. I talked to an old professor of mine. He's in his 80s. He's retired up in Monroe. He adopted several children, 4 from around different parts in the country. His 22-year-old daughter, that he had had a good life, came down with breast cancer at 22. Her doctors told her, you need to make sure your family knows about this because they may have cancer markers. So there are some negative what ifs that are potential and bad things have happened, but there are also good things that can happen when someone takes these actions like this. And I think in the interest of fairness and undoing wrongs that's the reason I'm here.
Now, in that particular scenario you just gave, the law would allow for adoptive parent in types of medical situations to locate their mother, correct?
Right. It would, if they had the resources to go to court. I got a lot of constituents don't have the resources to pay for a judge or 3 or 4 hours for a lawyer's time.
Very good point. Resources meaning money.
Yes, sir.
But isn't it not true that the state of Louisiana right now has a registry that would allow an adoptive child to locate their mother?
It is true, Representative Fontenot.
With no cost?
With no cost.
And can you explain that to us?
I can. Under the paradigm that was passed, I don't know what year was passed, I think 15 years ago. I think Representative Harris talked to former Speaker Downer about this, or someone did today. You did. You spoke to Speaker Downer about it, yes. This registry is passive in nature. I go out there and I put my name on it. And if my birth family put their name on it, if they happen to put their name on it, those dots can be connected by the state. In the last 3 years, I got these numbers from DCFS in our state. We've had a very small number of matches where these things have worked. There were 6 matches in 19, there were 2 matches in 20 and 20, and 0 matches in 21. So it was a good effort. I think it was a good faith effort, hoping people would be reaching out. But again, that obfuscates the point of this is less about the birth parent than it is about the other one getting their access to their information.
Do you believe that maybe a lack of use by adoptive children is just because of information, lack of information that this even existed, that this registry exists?
It could be, or it could be the proliferation of DNA, people going that way. There's lots of reasons.
This will be the last question for Rep. Owens.
It's okay.
If the registry connects a mother and a child, what do they do next?
Under the state's paradigm?
Yes, under the current adoption reunion voluntary registry by the state of Louisiana, what transpires next?
Well, let me back up a step. It's not a child, it's a grown person. So
My apologies.
2 grown people are connected by the state. The state has social workers and counselors get in the middle, make sure everyone knows what's going on, and they kind of still would treat me at 58 like a child.
So if the state mandates that some type of evaluation or counseling occurs before that physical contact, would you not believe that it could be a traumatic experience for both the adult that's adoptive and the parent?
I don't know that. I think what the law does, that this bill is strictly about a grown person getting access to their record from the state, and it makes it between 2 grown people without the state in the middle.
And this is where I started, Rep. Owens. I'm going to finish with this last question because I asked this once before, and I don't think we got a good answer. What's really the problem with having the mother agree to have this meeting?
Because she already agreed to relinquish her control of that person's life. She already agreed to disagree. She made the brave decision to let this child go and made the brave decision to go, I'm going to trust this to go another way.
Mm-hmm. And you think that that was her agreement, that now, even whatever she believed, because I think most of us in here thought there was some type of anonymous with adoption. Until you and I spoke, that's what I believed. You don't think some of those mothers had that belief when they gave their child away?
They may have, and I'll tell you this, Representative Fontenot, if I could, I would stare everyone in the face who had been through this, including my own family and my birth mother and my parents, and tell them that the state told you something that was not true, or an adoption agency or a lawyer or a social worker told you something that was not true.
I appreciate your passion, Rep. Owens.
Thank you for your time.
And I truly believe that the mother should consent as well. And if you are correct, and that all of these end in happy endings, then there will be no negative effect to get the mother's approval.
I don't know that they all end in happy endings, but I know that grown people deserve the right to their documents.
Question on the bill, Representative Wilford Carter.
So, Representative Owens, the argument is being made that the birth mother should have more rights than the birth child. What logic is there? Say the mother has a good reason why she don't want to be known. She got raped. How would that harm, if that child is an adult, he wants his birth certificate. He don't know why he was given in adoption. He have no clue. He just want to know who gave him in adoption, who his parents are. So he can try to have an idea of what his history is.
What his name was,
And
where
what
he
his
was
name
from.
was. And so I don't see how that harms the birth mother just by him getting that birth certificate. How does it harm the birth mother because somebody want to know where they came from? That's grown, that cannot inherit anything, okay? And so it seems like there's a perception that the birth mother should have more rights than that child that didn't actually come here, had no part in getting him here. He got here by two people. So if it had been bad, ugly, illegal situation, he had no part of that. So why punish him is my question. Why punish the person that's trying to find out where he came from and what his name was and who his parents was? Why punish that person that didn't participate in this at all, just happened to be here and he wants to know where he came from? I just can't see that the birth mother would have more rights than that child. They didn't contract nothing, didn't sign no adoption paper, did not ask to be born, but it's here. And that person have a right to know where that person came from. So he can tell his children where he is, who he come from. And I think you got a perfectly good bill, and I think we're making much ado about nothing, okay? And if that birth mother find out that child knows who she is, she don't have to talk to him, she don't have to have anything to do with him, okay? She don't have to respond to him, but he knows who he is and who the mama is, okay? That's all that's doing. So I don't see how the birth mother is being harmed. That's my only point.
Thank you, Judge, and that is why I'm standing here.
Representative Nelson for a question.
Representative Owen, how old does a child have to be before they're going to be able to request their birth certificate? Under
The grown person has to be 24.
Did you know I'm almost old enough for this bill to apply to me?
Thank you, Representative Nelson.
So a serious question I have for you. In the committee, we talked about at what point in the process does the birth certificate become sealed? Could you tell us when that happens?
It is my appreciation when the adoption is finalized in a court of law, that's when the adoption record, I guess the record and the birth certificate all become sealed at that point. But yes, it's after an adoption is finalized in a court of law.
So just when a baby is put up for adoption doesn't mean that it's sealed at that moment, right?
No.
And so it's not till that adoption is finalized. And I think the point was made in the committee that could be years or never.
Yes.
That could never happen.
Yes.
And so when we talk about whether or not there's an expectation for a birth mother to actually know that that this is ever going to be sealed,
yes,
a lot of times it's not necessarily given to a specific parent, that maybe they're given to some charity or something like that, and that at that point it's not going to be until that adoption is finalized, which could be years later. So there really is a pretty large period of time that could exist, or in perpetuity, that birth certificate was never sealed, correct?
That is exactly correct.
And so did you know that, at least for me, that was a pretty strong argument to say there really is not an expectation of anonymity, that really there is it was kind of surprising that in this pretty long period of time in that child's history, they could actually request that if they knew it was something that maybe one day could be sealed and would never be available to them.
Yes. Yes,
so
sir.
Really what we're trying to do with this bill is create some equity in that situation where this adult person after 24 is now entitled to get that same right that they might have had when they were younger and then lost through the adoption process, correct?
Yes, sir.
Thank you, Representative Owen. I think it's a great bill.
Thank you, Representative Nelson.
Representative Dustin Miller for a question.
Representative Owens, I'll just make a quick comment. First off, thank you for the bill. I have a guy who's really, really close to me. He's actually a family member who came down here, was adopted on the orphan train from New York. And right now he's 50 plus years old. He, all his life, tried to find his mom. And it wasn't until Ancestors DNA he was able to link some relatives back into Jamaica. By the time he found his mom through some relatives, she was dead. The stories he hears that she was depressed throughout her life ever since she gave him up because we think she was raped. But now he's able to bring his family to Jamaica, spend time with his kid, with his family, his relatives, and hear stories about who his mama was, and he finally know who he is and who's his family. So I just want to tell you, I think this is a good bill. With Ancestor DNA now, I think there's limited ways to not discover who your family is anyway. But for him, I think he would do anything he can to meet his mom, and I think she would have been in a better mental state if she would have been able to meet her son. So thank you for this bill, and I just want to share this story.
Thank you, Representative Miller.
Representative Furman for a question.
Thank you, Representative Owens. I know you have walked through this and lived it, and it's very important to you, and I really appreciate your position on this. Did you know that in the past few years we've opened a crisis pregnancy center in Central Louisiana?
I do.
And you would agree that's been a great thing. I
It has.
And my church was involved in that process, and my pastor, and it's something we've prayed a lot about, and so I've learned a little bit about what goes on there, and I know some of the young ladies that come into the crisis pregnancy center are in some really difficult circumstances,
Yes.
maybe 12, 13, 14, 15 years old, and it's taken a lot of prayer and a lot of counseling to get those young ladies to give that child up for adoption.
Yep.
Instead of aborting the baby. Do you think some of those young women were assured that this would be a confidential process and that there would be some anonymity involved, and perhaps that is what persuaded them to make that decision?
Well, let me answer that with a call I got this afternoon. We have a crisis pregnancy center in my little hometown. A lady named Latasha had emailed me one of those boilerplate emails that comes out that someone says, call to action, tell them to stop this. So I called her, I said, Latasha, what's going on? I said, I saw you emailed me. Can I explain to you what's going on here? And I did. And I drilled down with her, and she said, oh. She said, that's not what I thought that was. She said, I'm not against you. She said, I misunderstood what was being communicated about this. So, in that context, the people that run these crisis pregnancy centers are there because they are trying to take someone through a very tough moment. And I don't think they are ever thinking 24 years ahead. I think they're thinking about taking care of that young woman at that moment. And lots of times they're in there for lots of different reasons, Representative Furman. Sometimes they're down on resources and have just had a baby. Sometimes they're trying to get across the line. I would trust those grown adults to tell the truth about what's going on, because in the age of DNA now, as we continue to discuss, that's a non-starter. People will find you. And so I do not believe that is impactful at all. And I was glad I was able to get Latasha on the phone and clear this up.
Right. So you don't think that the 14-year-old girl who gave up her baby for adoption 24 years later, when she's 38, that's still a tough situation for her, don't you think?
It is.
Okay.
And as I talked about when Representative Fontenot was talking about, there are a lot of what ifs there, but I think this is the way to go for transparency and truth.
Is there any correlation that you know of, any hard data in regards to abortion and adoption anonymity? Is there any data out there one way or another?
I've not seen any. All I know is the statistics I reported of what's going on in Alabama since this went into effect.
Do you think there's a possibility that in the next couple of years we could see a dramatic decrease in abortions here in Louisiana?
You know, I would hope so, but I'm not standing up here for that. This bill is not about abortion. I hope so. I always hope that happens.
And if we see that dramatic decrease in abortion, would we also see a dramatic increase in adoption?
You know, I am always for more adoptions. We all know people who get into tough spots. We all know people who just decide they have to do that. And so, again, this bill is about giving a grown-up their right to their document.
Right. Thank you.
Thank you.
All right, let's take up some amendments before we move on.
Mr. Speaker and members, first set of amendments is a one-page set offered by Representative Charles Owen.
All right, Representative Owen on your amendment.
Mr. Speaker, members, I have an amendment that I am offering up as a good faith gesture to my friends in the life movement. I'm offering up something called a contact preference sheet. This is what is done in the state of Alabama. This is what's been going on in the state of Alabama while things have worked well. This is my good faith effort to step towards my friends. A person decides, well, let me back up. If a birth parent decides that they want not to have contact, that they contact the state, they contact DCFS, and they say, I prefer no contact. That goes into the file of the adopted grown-up. If the adopted grown-up at some point comes down the pike and says, I would like my birth certificate, that birth certificate is transmitted with the contact preference sheet that says, this grown-up, this parent, this family member request no contact. So that is a step in the direction. I had anguished over this. Most everyone who's told me to bring this bill told me to bring it cleanly without this, but there is such a concern, a valid concern over privacy, that I decided that this is the time to try this. So this provides a modicum of contact, shielding, but it will allow the person who receives the birth certificate to know what the birth parent or family member wanted.
All right, question on the amendment, Representative Boyer.
Representative Owen, I just wanted to make sure that I got it clear. So the child still has access to the original birth certificate, which would still have the original parent's information on it, with just a note saying, hey, here's their information, this is who Tim and Sally are, but they don't want you to contact them.
That's exactly right.
Okay, thank you.
All right. Question on the amendment, Representative McFarland.
Thank you, Mr. Speaker. Representative Owens, you and I have had a couple conversations about this, I've had conversations with the ladies in the back that's been here advocating for your legislation. And I think you've gone a long way in bringing this amendment. I know it was very challenging for you, but I think for many of us, you are beginning to address a lot of our concerns. Did you know?
Thank you, Representative McFarland.
Thank you.
All right, there are no more questions on the amendment. Any objection to the adoption of the amendment? Seeing none, the amendment is adopted. Next amendment.
Mr. Speaker and members, Representative Greg Miller offers up a 5-page set of amendments, 1720.
Representative Miller on your amendment.
Thank you, Mr. Speaker. First of all, I want to tell you that I can't express how much respect I have for Representative Owens, for bringing this bill and for working on this. It is certainly dear to his heart, and all the advocates who have spent so much time coming and testifying in committee and sharing their stories about this. But I contemplated bringing this amendment in committee, but I decided not to, and I have now thought about it and said I think we should have at least the opportunity to consider the amendment on this bill. We're talking about different parties and weighing the interests of different parties. And yes, I mean it's hurtful to be considered to be an object of a contract. But unfortunately, that's part of the deal. But also we have the parents of those mothers who have made that very difficult decision to give up a child for adoption as opposed to terminating a pregnancy or maybe raising a child where they just don't have the ability to. So I wanted to, before I talk about the amendment, this is relevant to the amendment. We have in our children's code voluntary registration. And our current policy that the legislature has found, and look, we're the legislature. We can change our policies. We can change what we find is in the best interest of the people of this state, of the adopted parents, of the adopted children, and everybody else. So I'm not suggesting that we are locked in, but I just want to make sure that we understand that we have, yes, the adoptions aren't sealed until there's been a process, until the adoption has been filed, but many times we have voluntary surrenders of the children, and the birth parents, the birth mothers, don't know what ends up happening, and they won't ever be able to find out because those documents are sealed. But in Article 1270, it says, adoption is based upon the legal termination of parental rights and responsibilities of biological parents and the creation of the relationship of parent and child between an adopted person and his adopted parents. These legal and social premises underlying adoption shall be maintained. It further goes on to say, the legislature fully recognizes the right to privacy and confidentiality of biological parents whose children were adopted, along with the siblings, adopted persons, and the adoptive family. So yes, we are changing. If we adopt Representative Owens' bill, whether amended or unamended. So the amendments that I propose would give the ability for birth mothers going forward, and I guess to the birth fathers as well, moving forward to consent. If there is no consent given, then upon reaching the age of 24, the adoptee would be able to get a redacted version, but would not be able to see the names of his birth mother if she has not consented, or the birth father. Or the biological father if he has not consented. If they have consented, then the adoptee would be able to get a copy of the non-redacted version. It doesn't go as far as the adoptee's wish, but it's an attempt at some compromise, and I know and I understand there will be objections to it, But I wanted to respect what we have had in the past as our policy of the state. But I would also respect if this body decides that we want to change that policy. So the amendment also clarifies that the birth mothers who conceived as a result of rape or incest are assured continued confidentiality. So, and then of course also upon death, if the birth parents had predeceased, then you would be able to get that information. I understand the question is, how do you find out? And if the death certificate has not been issued in the state of Louisiana and the child was born in the state of Louisiana, I mean, there's probably no way to know if somebody had given up the child for adoption here and had moved away. But this is some attempt. It doesn't go as far as Representative Owens and a lot of you would like, but at least it's moving that ball to open up the records more than what we have now, as well as not requiring the adoptees to have to go through the process of filing suit in court and having to prove that a heightened level to show why they need to have their birth certificates. So I'd be happy to answer any questions.
All right, question on the amendment, Representative Jordan.
Thank you, Mr. Speaker. Representative Miller, on your, I guess on this last part where it talks about protection for the birth mothers who are victims of rape or incest, molestation, would that have to result in a conviction, or would it just have to be an attestation?
I don't think there's a requirement of a conviction. I mean, and you know how tough it is sometimes, that a lot of times, sometimes these things are not reported, but I would be very doubtful that a birth mother would just make that claim if they didn't believe it.
I don't necessarily think that they would, and look, I'm certainly not trying to insist that or suggest that people would just say that, but I guess if not, let me say it like this. I think this is a difficult decision for some of us, did you know? And I'm not necessarily sure at this point how I'm going to vote on this bill, but in an effort to try to, I guess, figure it all out, I understand the first part of the amendment. I think, in my opinion, reduces the significance of Representative Owens' bill to a great extent, did you know? And then I think just by adding this other layer, I am concerned that it would create some hurdles for those who support Representative Owens at this point. It might create some hurdles that they may not be able to overcome, did you know?
I don't disagree that it creates a hurdle that wouldn't exist if his bill goes through as in its current form, but it's less of a hurdle than what we have right now.
I don't disagree with that. Again, I just think this is a tough decision for some, and I can see it in your face. I think you have some difficulty with it as well. Did you know?
Yes.
And I'm just trying to make sure, trying to give, and I told Representative Owens I would listen to all the arguments and try to give him as much benefit as I could afford him. And so I think in doing that, I just think it's my obligation to ask that question and to bring that forward. Thank you.
Thank you. And look, I'll tell you, I don't know a single person I've spoken to who didn't think that this was, that they can't see both sides. That doesn't mean that they don't have a strong conviction to come on one side or the other, but everybody that I've talked to have really taken this seriously, and I really appreciate all of the work that's been put into it and all the thought. I wish we could all be able to bring bills that with so much thought and conviction as Representative Owens has, and allowed the debate to go as Representative Owens has.
All right, question on the bill, Representative Larry Freeman.
Thank you, Mr. Speaker. Representative Miller, I'm reading through the amendment, and it seems to me that you're trying to create this registry which would affect all of the folks who have been adopted in the past, correct? This isn't a prospective amendment. This is to try to address retroactively, correct?
Correct.
And the way you're doing it is this public awareness campaign and trying to inform people, right?
Correct.
But you have, I think, and correct me if I'm wrong, but I'm reading that if a birth parent does not respond, it's a tacit rejection.
That is correct.
Why wouldn't you make it a tacit acceptance in a sense that if they don't respond, then they should be able to get their birth certificate?
I believe it's because of our current position of respecting the privacy of the birth parents.
So if they don't respond, you're saying that it is just a tacit rejection, and that way they don't, that birth certificate would not be released.
That's correct, unless you would have to go to court, or upon their death, if we have proof of their death. Obviously, the vital records would have to have that if they died in Louisiana.
While I'm not necessarily a fan of the amendment, making it a tacit acceptance makes it even less palatable to me. So, but anyway, thank you for bringing the amendment.
Sure, thank you.
Representative Harris for a question.
Thank you, Mr. Speaker, and I really like this bill and it's in its original form. But let me ask you a question on your amendment. What would happen if the natural father consented to the birth certificate revelation and the mother didn't?
In that case, they would be able to get the form redacted without the birth mother's information. And as a practical matter, then you find out who your birth father is, and you can probably find out from him who your birth mother was.
Well, that's where I'm going with this. I mean, it would only be common sense to say that the father would probably tell who the birth mother is.
Oh, I understand.
So it may even be more traumatic than what Rep. Owen has been talking about. So thank you for answering that question.
Sure.
All right, Representative Wilford Carter for a question.
Representative Miller, I'm trying to figure out if this amendment would apply to not just rape victims, but to anybody.
Not what?
It has to be a rape victim?
No, I mean, that's, we in amendment number 3, we say a birth mother who is a victim of rape or molestation deserves honor and respect. When a child is conceived as a result of rape and molestation, the birth mother shall have the right to privacy and be secure in her person, papers, and effects related to the records of adoption by which she placed the child with his adoptive parent or parents.
My problem is, on a birth certificate, it doesn't indicate whether you're a rape victim or anything else.
No, it doesn't.
Okay. Is there a registry of rape victims presently? If they have a child as a result of rape, do they place his name in the that person place her name in the registry? Presently?
No, there
so
isn't.
you want to create a registry for not just of rape victims, but for anybody that adopts a child can be a part of this registry?
I'm not sure if it's a registry for rape, but it's acknowledging that these parents, these birth mothers, they want a heightened sense of privacy.
Okay, so the state would create a registry, and this registry is going to be advertised for 1 year.
I don't think it would be advertised. I mean, we'll advertise that there is a registry.
Yeah, so you're going to spend money, the state going to spend money to create a registry and going to make an advertisement so people can know the registry exists. They can put their names on this registry.
Yes.
If they put their names on this registry, then you cannot divulge the information without redacting their information.
Well, we want to let people know about it so that they can at least decide if they want to consent to the release of these birth certificates.
In effect, your amendment would very much kill the bill.
No, sir.
All it would do is allow a person not to have to go to court if the birth parents consented, and they would have to, if they sign this registry, they will automatically be included in those that don't want to give up their information. So like had it been the other way around, it might not be as bad, because if a lot of people won't put the name on the registry, their name is not on the registry, then why can't the 24-year-old get the information?
If they've signed up and said, I'm consenting to my name to be released, then...
They got to say that they consented for the name
Correct.
to be released. Just putting your name on the registry is not enough. You got to consent to it.
No, well, I mean, you're consenting that you release your birth certificate. So the state Office of Vital Records would have that information that this child's mother has consented to the release. So when that child decides, I want to have my records at the age of 24, then they can go ahead and get that information.
But the birth parents, by putting the name on this registry, automatically consents, what you're telling me?
Yeah, well, I mean, I would suggest that they have to proactively agree to have their names on the registry.
But the amendment, does the amendment says that they have to, by putting the name on the registry, they are consenting, or they're not consenting? I'm not clear on that. It seems like it says by putting the name on the registry, they're not consenting for their information to be released without redacted.
Okay. I'm going to go to if a birth parent has consented to the release of their own personal identifying information on an adopted person's birth certificate, the Office of Children and Family Services shall coordinate with Vital Records Registry to facilitate the release of the non-certified copy of the birth certificate to the adopted person. And it goes on to say if only one, then they redact it for the other, and so forth.
But when you read it, it says the birth parent of an adopted person who registered with the voluntary registry may consent to or prohibit the release. So they have to decide whether or not they prohibit or consent on this registry.
Yes.
Okay. So it's not an automatic thing. You have to distinguish which one you want to do, and so that in effect, if anybody put the name on this registry, they identify they don't want to be released information, then this person can't get the information. He's 24, 50 years old.
Without going to court.
But you have an idea what it costs to go to court to get a judge to make a ruling whether or not the information ought to be released? Being a lawyer, there's no court cost right now under $300.
Unfortunately, that's true, Judge Carr.
And there's no lawyer going to try a case that might take several hours to give a reason, without probably about $3,000 or $4,000. So you're talking about having to pay up to probably minimum $5,000 just to get the judge to decide whether you should get the information.
No, and I understand, and you want a clean bill.
And that's the problem. So the problem is, while a birth mother, I kind of sympathize with a birth mother that is a victim of rape. If you limit it to just that might be a different situation. But to any parent, because she decided without the consent of the child to adopt the child somebody else, that child can't get the information because she put a name on the register and say, I don't want nobody to know. Now, she's a victim of rape. I can kind of understand that. So that's my problem with the amendment. And it's well intended to cut down the present problems by making it possible. But you're going to do an advertisement for a year, and then some people will put their name on the registry. If they don't put the name on the registry at all, will this allow the child to get the 20? If they don't, one way or the other, you're forcing the child to have hope that their mother and father that gave them away would sign this form registry and consent. That's a big loop.
I don't disagree with you, and I look, these are not easy situations.
All right. Question on the amendment, Representative McCormick.
Yes, Representative Miller. Do you have a fiscal note on this amendment?
Do I have a fiscal note on this amendment?
Yes, sir.
No.
Did you know it sounds expensive? also, I'm going to give you another did you know. Did you know sometimes I think with good intentions we try to go out and run down every one of these rabbit holes and solve all these problems, but did you know that I think it's better for government to just get out of the way and pass the bill? But I appreciate your intent.
I appreciate your position.
Thank you.
Yes.
All right, question on the bill, Representative Ivy.
Thank you, Mr. Speaker. Just for clarification, because I heard adding your name to the registry, are all of these elections of the birth mother to keep their information confidential or to allow it to be released, is that all held in confidence within the vital records and the registry?
Yeah, I mean,
it's not a public record, right?
Yeah.
So
I don't believe that it would be. It's part of the.
Okay, just making sure that this is not a list of names where people can go check and see who's provided names. Okay.
No, I don't believe, but I guess that's always
Question
something.
on the bill, Representative Landry.
Hey, Brett Miller, I'm sorry if I missed this earlier, but if someone was a rape victim, they would opt out of this process?
No, I think there would just be a little heightened. We're just showing that we're saying that we're adding that a birth mother who is a victim of rape or molestation deserves honor and respect when a child is conceived. As such, the birth mother shall have the right to privacy and secure in the records the adoption by which she placed the child with his adoptive parent or parents. So I think it's a little more heightened scrutiny there for those who have said that they were victims of
so would
rape
there
or molestation.
Be like a list or an asterisk or something?
I can't tell you how we would actually implement that,
this?
but the point is that they wouldn't ask, they would, I guess if they agreed to consent for their, for the original certificate to be released to the adoptee, then certainly that would be on the list.
I'm a little confused by, I was looking at your amendment, so I was a little confused by it, but I also have some advocates telling me that they think there's a chance this would require a raped or assaulted birth mother to tell someone that during the adoptive process. And generally how that works is a lot of times it's just unknown father. So, I'm worried if this would.
Yeah,
do you
and
think
I'm not
this
aware that I'm not aware that this amendment would require an active act on behalf of a birth mother to state either one of those. But that's part of the privacy that we have afforded traditionally in this state. So, and whether you've been a victim of rape or molestation, or whether you just had a situation where you just didn't want people to know. But I understand that flies 100% against what the adoptee's rights are. So, I mean, there's certainly a conflict.
Yeah, you
I
do
acknowledge
raise
that.
a point that I've been curious about this whole time, that the privacy or the confidentiality that we've been discussing, it's my understanding that it's between the birth mother and the adoptive family. Is that correct?
It goes beyond that. I mean,
Is the state a part of an adoption contract?
Well, I mean, look, when we have a confidential, an adoption where a voluntary surrender, that there is no expectation that there's an expectation that you're not going to know who's going to be adopting your child. And often you don't know who had given up their child for adoption. But, we've said it's based on the legal termination of parental rights and responsibilities of biological parents and the creation of the relationship of parent and child between an adopted person and his adopted parents. These legal and social premises underlying adoption shall be maintained, and the legislature fully recognizes the right to privacy and confidentiality of biological parents whose children were adopted, siblings, adopted persons, and the adoptive family. So we're recognizing all of their rights to privacy, not just vis-a-vis each other, but vis-a-vis the whole world.
But just back to my original question was that contract does not involve the state of Louisiana. It involves two private parties. So I'm just not sure how we can have that blanket coverage, what Rep. Owen points out repeatedly, as a public document. I mean, the state is not involved in this contract, so how are we even, I don't even know how we're having this question. This should be allowed.
Well, I understand. If you believe that the state shouldn't be involved, then why do we have adoption laws?
Well, to protect people from being coerced, for example.
Well,
I mean,
the state does get involved with these laws, and that's part of what we have as a state have recognized. Now, if we want to change this going forward, that is our right.
Okay, thanks.
Representative Edmonds for a question.
Thank you, Mr. Speaker. Chairman Miller, in both directions, going forward, does your amendment have anything to do that prohibits a change of direction of how we handle adoptions, privacy, records, any of those things that we're discussing going forward? Does this amendment have anything to do with that?
Well, yes. I mean, it says going forward, anyone who's 24 years of age may request the release of a non-certified copy of his original birth certificate.
Okay, so that moves us in your opinion, the proper posture going forward. Now, going backwards, one of the issues that's been difficult, and all of us are trying to deal with it, is the privacy area of adoption and its documentation and how we deal with that. So, in going backwards, if we think we have made the state, framing the laws, children code, etc., that we have a responsibility to these birth parents or mother, what does your amendment do to assure that their privacy is not violated if we go backwards?
It creates the registry that allows either the parents to either consent or to prohibit the release of consent to the release or prohibit the release of the information.
Okay, so it sounds like a little bit, again, I think those are the two main concerns. Can we go forward and make some adjustments, and can we maintain the privacy if we go backwards? Did you know?
Correct. And look, this is, you know, there's no perfect answer.
I know.
Okay? The perfect answer would be I don't know if there's a perfect answer. Every individual is different. Every single individual. And yes, we have changed as a state. It used to be a stigma to have a child born outside of marriage. There is no more of the stigma. We celebrate the birth of children, and we want to encourage adoption. And I salute your work, and I salute everyone that promotes life. And you know, I want, but also have to acknowledge where we have been as a state. You know, so, but I respect everyone's position on this, and you know, if this is the will of the body, fine.
Thank you, Representative Miller. Thank you, Mr. Speaker.
Representative Nelson for a question.
Chairman Miller, my question kind of alludes to what we talked about earlier. So with this, we pass your amendment, would the compelling reasons that we already allow under current law, would that be impacted at all?
I believe that if the parents, the birth parents, did not consent or said, I want to prohibit it, I believe the compelling reasons would still be allowed for someone to get their information as we currently allow.
So even if the birth parent said, I don't want my information released, it would still be possible for the information to be released, correct?
That's my understanding of my amendment.
And then what about the situation, like we said, where we put them up for adoption, but they were not necessarily adopted? Would it still, then the information would still be available to the
Yeah,
everyone,
because
right?
if you don't have a new birth certificate issued then you still have that existing birth certificate, and you should be entitled to get that birth certificate.
And so just kind of following that logic, is this really going to protect the birth parent, or is it really the adoptive parents that benefit from a different?
Look,
it doesn't exist in that situation.
It's not an all or nothing. It's not an all or nothing. I guess that if there's a chance when a person's rights are terminated in their child, or if they have voluntarily surrendered, I guess there's always that chance that the child would not be adopted. But I hope they all get adopted.
Thank you.
Sure.
All right, there are no more questions to the floor on the amendment. Representative Seabaugh.
Thank you, Mr. Speaker. This is a difficult one for me. I got elected in 2010, and in all the time since then, I have never taken the floor against Louisiana Family Forum and Louisiana Right to Life. I have nothing but the utmost respect for what they do in this state to protect the unborn. This is not an abortion issue. And quite frankly, what they have done with this bill is create a red herring where none exists. They've created a fiction about confidentiality and anonymity of the birth parents, which was never the rule, it was never the reason that the 1977 bill was passed. It was never passed to protect the anonymity of the birth parents. That was not the basis of the bill. The basis of the bill at that time was to protect the adopted kid and the adopted parents, not the birth parents. That fiction did not exist. It didn't exist in 1977. It certainly doesn't exist now, where 23andMe and Ancestry can tell you in 6 weeks if you spit into a cup who your birth parents are. All you have to have is a second cousin of the birth parents who filed for the registry, and you can find them like that. There is no expectation of anonymity. It does not exist. Now, granted, it might have existed in 1980. It might have. But it doesn't exist now. This bill is not about abortion. It is not about anonymity and protecting the rights of the birth parents. It's about your vital record. It's about Representative Owen's vital record. His name is on a birth certificate out there that he can't see. Think about that. It's his. It's got his name on it, but he can't see it because the state says you can't. Now, this amendment, while creating another government bureaucracy, which as a conservative, I'm against. The opening up the vital records, I'm against. The creating this registry and contacting spending state money to call people and say, oh, by the way, you had a baby in 1982. Do you want us to tell anybody about it? Who wants to have that conversation? If we're trying to avoid the unwanted reunion, that cat left the bag when 23andMe went online. That unwanted reunion is there for anybody that wants to spit into a cup and mail it off with $100 or whatever it costs. And look, I have a very close friend and family member who is adopted, and he has adopted a child. They love Representative Owen's bill and they oppose the amendment. He does not care who his birth parents are. He doesn't care, but he's not going to contact them. But he's no interest in contacting them. But he would like to know who they were for medical purposes or for other things, which goes back to the law as it exists now. If you have money and can hire a lawyer, you can get your birth certificate now. All you have to do is show compelling reasons. The only people who can't access it now are the people who can't hire a lawyer, don't have access. This bill, right now, compelling reasons, the bar is very low, and I've talked to 0 people who hired a lawyer, petitioned the state, trying to get their original birth certificate, who were denied. 0. I've also been contacted by 0 birth mothers who didn't want this bill to pass. Now, Family Forum and Right to Life likes to say, they're out there, they just don't want to contact you. I would love to be able to come up and say, I know nobody's giving you an email against my bill, but I promise, for my bill, but everybody's in favor of it. Just take my word for it. That's not the way it works. If nobody has contacted you, they're probably not out there. I know you've been contacted by the ladies in the back and you've been contacted by the people for this bill. This amendment, with all due respect to Representative Miller, wherever he is, and the Family Forum and Right to Life, this amendment guts the bill. It guts the purpose the bill was brought. You can't create a registry and go find people. I mean, the adoption was done in 1980. You have to go find them. If they're dead, who's going to look up and see if they're dead? We're going to create a government bureaucracy. We're going to have paid government workers tracking down birth parents. Come on. If you want it, you should be able to write a letter. You should be able to get it. That's it. And look, I'm going to close with this. This was passed in 1977. Back then, if you can rewind back then, the #1 pro-life legislator in this body was Woody Jenkins. He carried every pro-life bill. He voted against the 1977 amendment, which closed this. It's not, and by the way, he favors this bill without the amendment. This is not going to enhance or increase abortion if we close this, or excuse me, if we open this up. Anybody right now going forward knows that 23andMe and Ancestry are there. They know if they bring that child into this world, they can spit into a cup and their name will be known. They know that. That is a red herring created to oppose this bill. Why? I have no idea. I encourage you to ask them. I'm sure they have a good reason, but it is not about preventing abortion, and it is not about any promise of confidentiality or anonymity that was not made at the time. That was never the reason for the bill, and quite frankly, it doesn't exist now. When 23andMe and Ancestry went online, all of that confidentiality is gone. What this is about, and this amendment seeks to prevent, is for people like Representative Owen to be able to write a letter and get that piece of paper that is their own vital record with their name on it. Government should not block your access to your own vital records. Now, please join me in preventing and killing this amendment. Thank you.
All right. Representative Miller, would you like to close on your amendment?
Thank you, Mr. Speaker. Look, I understand the passion on the sides. You never heard me mention one bit about whether this amendment would support the efforts to keep children and keep mothers from terminating their pregnancies. I'm just telling you that we have recognized that right to privacy and confidentiality before, and this is an attempt to try to keep some of that. But with that, I ask that you support the amendment.
All right. Is there any objection to the adoption of the amendment? There is an objection. All right. Members, Representative Miller offers up an amendment which Representative Owen objects to. All those in favor of the amendment vote yea. All those opposed vote nay. The clerk will open the machines. Members, vote your machine. Hughes, no. Miguez, yes. Turner, no. White, no. Green, no. You through voting, members? Through voting? Bishop, yes. All right. Close it up. 23 yeas, 73 nays, and the amendment fails to pass. Next amendment.
Next set of amendments, 3-page set of amendments by Representative Ivy, 1673.
Representative Ivy, on your amendment.
All right. Thank you, Mr. Speaker. Members, we've had a pretty lengthy debate so far. I'm going to be brief. First of all, I have to appreciate my colleague, Representative Owens, who, as far as willing to be open and objective throughout the process and just really putting in every effort he can to try to come to some common ground, I have to applaud his efforts for that and appreciate it. My amendment goes a lot further than the other amendments in a prospective manner. I feel there's some fundamental issues with the bill in its current posture. I have spoken with the Right to Life, Rep. Owens, and some of the other advocates, and I believe that the bill paints with too broad a brush. So I tried to come up, with some common ground, and I believe this goes a long way, but it just doesn't go as far as Representative Owens would prefer. And I will say that out of deference to, and sometimes I do offer this option, out of deference to my colleague and his desires, I am going to withdraw these amendments, but I wanted to highlight that there's a lot of opportunity for us to continue working on this. And if this bill doesn't pass in its current posture, I believe there's some very strong opportunities to really get most of the way there. When we don't account or accommodate, and in the bill that I have, prospectively, I allow, the rule becomes that at 24, you get a copy of your unredacted birth certificate. One exception, the exception being that in the process of adoption, that a birth mother can petition the judge and through a form, so we make it fairly easy, where rape, incest, or any other compelling and extraordinary circumstances may necessitate that those records be permanently sealed, with the exceptions that currently exist in law. That's it. And so we require judicial action to maintain that confidentiality. So I believe that's the right direction going forward. Prospectively, it gets very difficult because, again, despite the arguments that have been made with regard to no expectation of confidentiality, when you read the law, it says confidentiality, 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 and the exception to the law, as has kind of been discussed, is it's pretty onerous. You've got to hire an attorney. You've got to get a judge to open that seal, and they only do it under kind of extenuating circumstances, health and other issues. And so the fact is, the law as it currently exists does provide some expectation of confidentiality. And while I'm very sensitive to all parties concerned, I fear that we are not being sensitive enough with the individuals where there could be significant implications to the release of these records with no regard whatsoever to their situation. So I believe we should take more care. I'm going to withdraw this amendment, but as you vote, consider that, look, if this fails, we can bring it back up with and put a little more elbow grease in an amendment. So with that, Mr. Speaker, I withdraw, and I will not speak on the floor against the bill. So.
All right, there are no more amendments. Back on the bill, to the floor on the bill, Representative Harris.
Thank you, members. If you'll just indulge me a moment, I want to talk about something that I don't ever talk about, and I find very difficult to talk about. When I was a kid coming up, there were 5 of us children in my family. Had an older sister who my parents had naturally at 50 years old. And then my mom and dad adopted a son in 1955. And then they adopted another son in 1957. Then my other brother was born in 1958. Then I was born in 1961. And being raised in that kind of environment, back then it was not open adoptions like there are now, and that's why I'm involved with VOA. But my brothers really never knew that they were adopted. I didn't either. And when we'd go out to play, everybody say, "You look different than Lance or Brooks." Or there seems to be a difference. There was always a question to my adopted brothers as to where they came from. And as we got older, they started asking those questions. When we'd have family discussions or family arguments, once they found out that they were adopted, they would say, "I don't know where I'm from. I don't know what my circumstances were." Well, both brothers are deceased. One died in 1976 when I was 15. One died in 1981, both of them by suicide. And that question always was on their mind. Now, there were other things, of course, in the 70s, but just think, one of them died at the age of 24. Just think if he would have had the option to answer at least some of the questions he had as an adopted child. But no, we're trying to fix that, where the state now locks that up. I would ask that you pass this favorably, because there's another side to adoptions besides just the birth mother. These are human beings that are brought into this world. They're special people. They're wonderful, and they deserve the right to know their origins. So thank you. I ask for your favorable passage of this bill.
All right, to the floor on the bill, Representative Amity.
Thank you, Mr. Speaker. Members, I don't know about how your legislative assistants are doing back home, but I know that mine sent me a big tally on this bill last week whenever it came to committee and then when it came to the floor. And just wanted to share something with you. At my office, we've received 15 contacts from adoptees, 17 from adoptive parents, 11 from birth mothers, 2 from lawyers and professors, 21 others uncategorized, 10 different organizations, and 1,365 members of Mothers for Open Records. That's 1,441 contacts in support of the bill. At my office and here on the House floor, we've received 2 contacts opposing the bill. Now, those 2 contacts are organizations that I highly respect and I've worked with for years and will continue to do so. Both Louisiana Right to Life and Louisiana Family Forum have opposed the bill, and both have given me the same reason, and that is that they fear the passing of the bill might lead to an increase in mothers choosing abortion over adoption. Now, what we've heard today is that the statistics that are available show otherwise. What I've heard from my office is that a whole lot of mothers took the time to contact my office, urging that we keep records open. So I've prayed the whole time, in committee last week and the week before, and when the bill was here on the House floor, and over the weekends. And one thing keeps coming to mind, because as we talk about here in the House, especially in our opening prayer time, is that when we have a tough decision to make, the main thing we should do is pray. And so I did. And I kept hearing one thing over and over: truth sets free. My mother was illegally adopted in 1941. She knew that the father that raised her was certainly not her father, because she was 3 years old already whenever he married her mother. What she didn't know all her life was that that wasn't her mother either. After her parents that raised her had both passed away, on her 56th birthday, her sisters gave her the original birth certificate that she had never seen. And I remember the effect it had on her. I remember the relief that she felt when she finally knew some truth, when she finally learned about the reality of her very own beginnings. I remember a lot of the lifelong questions that she had were answered that day. She was so excited, she went to a store and photocopied the birth certificate, and she mailed a copy to me and to my sisters, and we all celebrated truth. In adoption agreements, opportunities and policies already exist related to whether the birth parents and the offspring want to meet or don't want to meet. But this bill isn't about meeting. It's about a government document with your name on it that you're forbidden to see. It's about the many questions that go unanswered when such a key document is withheld from you. It's about having access to that document. Fear keeps us bound. Truth sets free. So I urge you to join me in voting in favor of House Bill 450. Thank you.
All right. Representative Owen, you want to close?
I do. Thank you, Mr. Speaker. It's not the job of government to be the custodian of secrets, or not these kind of secrets anyway. I firmly believe in our great state we need a draconian law review. We've seen some terrible bills taken off the books here. Representative Moore took one off a couple of years ago. Meandering, something else. Representative Marino got one done last year that reimbursed people who were wrongly convicted of crimes. When the government makes mistakes, it's incumbent upon the government to correct those mistakes. And even though things are done with good intentions, they often don't turn out well. And it's our job to be here to do this. I want to honor everyone who's a part of that adoption triad. The birth mother who I spoke of today, who I love dearly and wished I'd had more time with her. The child who becomes an adult and the adoptive parents, and they all need to be honored, and they all need to be protected equally under the law. The purpose of House Bill 450 is to restore access to the piece of paper that records and verifies one birth. I ask that you pass this bill as amended. Thank you.
All right. Representative Owens moves final passage of the bill. All those in favor vote yea. Those opposed vote nay. The clerk will open the machines. Members, vote your machines. Vote your machines, members. Bishop, yes. Dustin Miller, yes. Hughes, yes. Green, yes. You through voting, members? Greg Miller, yes. You through voting? All right, close them up. 75 yeas, 21 nays, and the bill is finally passed. Representative Owen moves to adopt the title, moves to reconsider the vote by which the bill was finally passed. Lay that motion on the table without objection, so ordered. Open it up for co-authors. Co-authors, members. Vote your machines. Vote your machines for co-authors. Green, yes. Hughes, yes. You through voting, members? You through voting? All right, close them up. 25 co-authors. Next bill.